Okay, I think we've got quite a lot of people in, so we'll start now. A very good afternoon to you all, and thank you for joining us for our Expert Determination webinar for legal professionals. My name is David Bell, and I'm a Managing Director and Forensic Accounting Specialist within the Disputes, Investigations and Valuations team here at Quantuma. For those of you who are unfamiliar with Quantuma, we're an independent advisory firm serving the needs of mid-market and corporate clients and their stakeholders. We advise clients on business transactions, resolving business disputes, mitigating risk, and managing operational and financial challenges. We regularly work with legal professionals to help them support their clients in a whole range of disputes, including expert determinations. I'm joined today by three of my colleagues from our Disputes Investigations and Valuations team. We've got Kate Hart, who is based in our Guildford office, Gavin Pearson from our London office, and Rob Parry in Manchester. And for completeness, I'm based in our Glasgow office, so we have a good geographical spread across the UK. So in terms of high-level agenda, we'll be covering three main phases of an expert determination, with Rob covering the drafting phase, Kate will be taking us through the appointing the expert phase, and Gavin will be covering the during the expert determination phase. We'll then have some Q&A with the speakers to answer some of your questions at the end. We've split this session across what we consider to be the three most important phases that impact expert determination as follows. Drafting, this is before there is any dispute, but anticipating there may be a dispute, because often there certainly are disputes when it comes to SPAs, transactions, and so on. And it's about getting the agreement for expert determination right, whether in an SPA or in any other contractual agreement. Then appointing, this is agreeing the terms of reference and procedure for the expert. So this is obviously at the point when the parties are now in dispute at that stage. And then during, this is addressing some of the issues that come up during the actual determination process itself. Before we get underway, and before I pass over to our first speaker, a few bits of housekeeping. Today's session is being recorded and will be available and circulated to everybody next week. There is a Q&A function open on the Zoom, so please feel free to submit questions as we go. We've had some questions from people submitted already, which is excellent, but please do submit as we go, and the questions will be confidential from everybody. And for the avoidance of doubt, we're treating this session as a without prejudice and safe space. So it should be an open discussion. Chatham House rules will apply, as you would probably expect. So thanks for your time today. I hope you enjoy the session. I'm sure you will enjoy it. If you want to reach out to any of the speakers after the webinar, we're more than happy to have a chat with you. Our contact details, excuse me, contact details will be appearing at the end of the presentation. So please feel free to reach out to any of us. And without further ado, I'll pass you over to Rob Parry, who will take us through the drafting phase. Over to you, Rob.
Thanks, David, and thanks everyone for attending. So you've seen that my slot is to talk about the drafting. Well, clearly I'm not a lawyer, so I'm not qualified to draft legal contracts. But what follows is really our perspective, or perhaps more particularly my perspective in this instance, of drafting that can help avoid some of the pitfalls and expert determinations, which is what we really see this session as about. So the expert determiner's jurisdiction is absolutely strictly controlled by the terms of the relevant contractual determination clause. And so without any later agreed amendments between the parties, when activating the determination clause and making the appointment, the original clause alone defines the process and the jurisdiction. And that's a really important point that people have to remember. And Gavin is going to speak later about experts going off piste, i.e. acting beyond their jurisdiction, and what you might be able to do to prevent that. What I'm suggesting in this drafting is the thing that's to try and define that jurisdiction, to try and keep them from going off piste, and in fact keep those instructing an expert determiner from going off piste, because sometimes they've got a tendency to try and ignore what's been agreed. And when discussing our approach to this webinar, it was apparent there's a fair amount of overlap between what I'm talking about, drafting the upfront expert determination clause, and what Kate's going to talk about in terms of actually appointing the determiner. What I like to think is you can get as much of it as you can into the upfront drafting, rather than having to agree it later when there is a dispute, because clearly at the early stages of a discussion, when people are negotiating, if it's an SPA in an M&A transaction, at that point, the dispute clauses are subsidiary to the main issue. So it's probably easier to get them agreed at that stage. So David, if I could have the first slide up, please. Thanks. So I've put a first bullet point as avoiding the need. And really the first part of the expert determination clause to me is to try and draft the rest of the contract so that you don't actually need to enable an expert determination clause. So spend a little bit of time on that. The two areas where I've seen most need is after corporate transactions or in other disputes between shareholders. So taking the corporate transactions, typically a sale and purchase agreement, an SPA, as we keep abbreviating it to, taking SPA as the most common for us. It's often the completion accounts or earnouts that give rise to a dispute. And quite often, if we're getting involved, it's because there's a perceived ambiguity in the accounting or financial terms being used. And I think to help avoid that, you can get the SPA reviewed in advance by someone used to identifying common issues. I mean, perhaps that's a Mandy Rice Davis saying, I would, wouldn't I, in saying that. But I think that's quite important. And I'd say try and be as specific as possible in defining the terms that go along with, let's say, an earnout or a completion accounts process. And so, for example, where there's a specific accounting term, like, for instance, provisions for potential bad debts. So a vague statement that we might see says something like, all debtors where payment is uncertain should be provided for in calculating EBITDA in the earnout period in the same way as in the last annual accounts. Now that's a bit vague because the seller's going to say, well, I always did it this way. And the buyer's saying, well, we don't think you did. And it gets into dispute. So why not have something more clear cut, something that says maybe the EBITDA in the first earnout period shall be calculated allowing full provision for all trade debtor balances outstanding at the completion date and not paid in full by the end of the first earnout period. So there you're defining quite clearly that in that case, if a debtor's not paid by the end of the earnout period, it doesn't come into the accounts, it falls out of the EBITDA. And it's quite specific rather than referring to judgment used in the past. And so by having that sort of level of specific clarity, you should hopefully help avoid a dispute over the level of provision for bad debts, and that'd be one less thing needing to be determined. And I'd also say for shareholders, try to avoid just relying on what's in the Articles of Association, which I'm going to come back to shortly. But those are often drafted years ago. They have outdated clauses in them. So again, if you're a corporate lawyer on this call or anyone with regular corporate clients, get your clients to have a well-drafted shareholders agreement in place that covers what might happen. I think David said, this is most commonly pre-dispute drafting the clause, and that that is so. So what we're talking about in something like a share purchase agreement, the objective is to specify the process before a dispute happens. But I've also, and less frequently, been instructed where a dispute is ongoing, and rather than carry on through formal litigation, the parties have agreed to go to expert determination. And typically this would be something like a shareholders agreement, a shareholders dispute, under section 994, and the parties agree that, right, rather than continuing with litigation, why don't we agree an expert determination clause, agree it in a contractual position, and then it's the valuation that's the issue, because the issue is more financial than legal. So there's a preference to avoid the sort of further risk of litigation. I mentioned briefly articles and auditors. I've often seen the articles drafted that say where there is a dispute between shareholders, and in the situation of a departing shareholder who might be a good leaver or a bad leaver who wants to sell their shares, that the value is to be determined by the auditors acting as expert. Well, it's very likely at least one or both parties will not be happy with the determination. It's that sort of role where you don't necessarily make friends with both sides. Sometimes you make friends with one and, you know, this is after the determination. Sometimes it's neither and they're quite happy. But the point is, if you're the auditor and it's the remaining shareholders that are unhappy, then the auditor might find themselves replaced. If it's the existing shareholder that's happy, then there might be an accusation from the departing shareholder that the auditor has favoured the remaining shareholders. It's a conflict of interest, to my mind, for the auditors to act between shareholders. So my recommendation to auditors is don't, and the shareholders agree, you know, something different in the shareholders' agreement. What's the overriding objective of expert determination? And that's key to the drafting. So why have the clause in the first place? From the point of view of the accountant and valuer expert determinations, it's because the issues are financial, accounting or valuation based rather than legal or factual. Because the issues are not necessarily ones of law, it may be viewed as better to have an expert in the field make a determination rather than going through litigation. And in theory, and importantly, the process should be quicker and cheaper. The parties should also have greater control because they can specify in advance what is and isn't to be taken into account by the determiner. And a key objective is finality. The determination needs, in most cases, to be binding on the parties, save manifest error. If it's not binding, then, you know, almost what's the point of going through the determination process? And I'll just make a quick point on what expert determination isn't. Excuse me. It's not acting as a single joint expert. I've seen instances of expert determiners proposed, and when they send through their terms, they talk about their duty to the court, acting as a single joint expert, and CPR. Those things are, of course, completely irrelevant in the role of expert determiner. The expert determiner is appointed by contract, agreed between the parties. CPR and duties to the court don't come into it. And just to contrast the two further, obviously a single joint expert is providing an opinion and potentially a range of opinion on something like evaluation to assist the court in arriving at a judgment. That's very different to the expert determiner, who can't give you a range of answers. They've got to give you, this is my determination. They've got to nail a flag to the mast and stick to it. Again, important to define what is going to be determined. This might sound like an obvious one, but some of the expert determination clauses I've seen, it isn't. A classic vague term is one for the selling shareholders in the articles. And I've seen this time and again, and it will say, the value of the selling shareholders' shares will be determined by an accountant of not less than 10 years standing, acting as expert. So that all sounds quite sensible at first glance, but what does value mean? So if you ask an experienced valuer, can you value this? They'll first say, well, what do you mean by value? So does it mean market value? And market value is broadly the price that the shares could be sold for in the open market in an arm's length transaction. Could it mean fair value, which is broadly the price that reflects what's fair as between identified parties and reflects their respective positions? It's not an arm's length value. And so one thing that does alarm me is it's quite frequently I've seen clauses refer to fair value when subsequent wording made it clear what they actually meant was market value. So the definition needs tying down in the document. So for example, if you are wanting market value, say market value is defined in connection with the international valuation standards as applicable at the date of valuation, rather than leaving, well, later on there's an argument about what does value mean, because I've seen that happen where one side says, well, this should be fair value, and one says it should be market value. Define it up front. Items not disputed, an area that sometimes causes query is where you've got some items in, say, completion accounts are agreed and others are still in dispute. Unless the determination clause prevents it, there's sometimes an attempt to put everything back on the table and back in dispute when it goes before the determiner. So to avoid this, I think the clause should require a dispute notice, which clearly sets out what items are agreed and what are disputed and why, and makes it clear that it's only the unresolved items in the dispute notice can be determined. And that stops somebody going back and saying, well, okay, if you're not going to agree with me on these 3 items, I want all 10 to be determined. If you do the next page, please, David. So selecting an expert in advance, it's a tricky one. This I've previously suggested, I think, in an article that it's a good idea, but it can leave one party exposed if the other party has or gets a connection with the nominated expert when there's later a dispute. And where that can be a problem, for example, is where a large, say, international buyer says, well, it must be a certain size of firm that does the determination. Quite likely that over time they might have developed a connection with that firm. And whilst I don't believe, any of the major international firms where the determiners work would actually be biased or impartial, it always leaves a slight uncertainty in the minds of the non-connected party. I think it's helpful to narrow down the choice of expert, but be careful what you agree to. And this is something Kate's going to come on to further in the appointment. Rules to be applied or varied. Quite helpful to have a look at this if you're doing a determination. Have a look at the Academy of Experts or the Institute of Chartered Accountants. They've both published rules on expert determination, and you can review those and incorporate them or a tweaked version into an expert determination clause, or it'll certainly give you a bit of a checklist of things to remember when appointing a determiner. Timing, I've seen clauses that say, the expert will provide the determination within 7 days of instruction. Well, my simple answer is it's very unlikely that that'll happen. An experienced expert will just say to the parties, right, well, I want you to agree to vary that term because the timing's got to work for me. I need to, compile what information I need. So you could say, the timing is to be determined by the expert and perhaps give sanctions for non-compliance. But I don't think there's any point agreeing an unrealistically short timetable. Access all areas. Again, quite often see at a company sale, it'll say, well, the selling party won't have access to the financial records. And if there's a dispute, it'll say, well, the selling party can have access to the financial systems. I've never actually seen that be taken up, because how can a former shareholder turn up and access the financial systems? Better to cover it, recover compliance with reasonable requests, and the expert be given right to require further timely disclosure, or even to be able to draw adverse inference if a party refuses to disclose something relevant. I think the clause should cover submissions as well. You can go into reduce the requirement for the expert to allow submissions and reply submissions. You can prescribe that up front. I mean, if the parties decide later to vary it by agreement, that's fine. But I think as a minimum, you want to allow submissions and reply submissions. I'd also give the expert right to sanction or to ignore any submissions made outside the expert's agreed process. I've seen a number of cases where there's been submissions in accordance with the agreed process. There's been reply submissions in accordance with the agreed process, but then one side just can't help themselves and have to say something else. That obviously then can set the whole process back. Delaying tactics, strong drafting. Excuse me, my lights have gone out. Strong drafting and agreeing as much up front as you can help prevent delaying tactics. But Kate is going to address how and why some parties will use them and what can be done to avoid them. Speaking or non-speaking, again, Kate will come on to say more about what the difference is between a speaking or a non-speaking determination and the pros and cons. But I think it can and ideally should be specified in the expert determination clause. As I say, if the parties decide later between them, actually they'll vary that, that's fine. But the point is, at least if you set it out up front, it can't be used to cause a delay if the parties don't agree. Two more important points: payment terms. and the relevant clause needs to cover the enforcement of the determination with a timetable to pay if it's a financial amount after the determination. No point getting a determination and then somebody's forgotten to put in what the payment terms are to comply with the determination. And similarly, cost allocations. Kate's going to cover some cost allocations, and there can be alternative ways of dealing with it up front. And again, it might be easier to agree this before there is a dispute to avoid it being used as a delaying tactic or a negotiating lever at a later stage. So cover the payment terms for the dispute and also cover how the cost allocations are going to be done. And with that, I'll hand over to Kate.
Thank you, Rob. Okay, so once you've agreed that you need to resolve a dispute by expert determination, the next stage is appointing the expert. So I'm going to cover some of the main aspects of this stage, primarily comprising key terms of reference that might need to be addressed, how you go about agreeing these terms, and some thoughts on the output that you might want from the expert. So on to the next slide, David, please. Although you've agreed to appoint the expert, it's important to understand that they can't actually compel the parties to do anything until they've been appointed. And the main issue here really is the potential for delay. Rob mentioned that before. If one party is expecting to have to pay out as a result of the award, and they usually are, because usually going to expert determination, somebody knows that they're the one that's going to have to pay up in the end. They probably want to drag their heels. They might want to slow down the process. It's quite easy to do this. You can fail to engage in the process to appoint the expert entirely. You can quibble over tiny clauses in the expert's terms of reference, so that you don't like this and then you don't like that. And Rob said that I'd tell you how to get over this problem, but in reality, there isn't really anything that the expert can do because they haven't actually been appointed yet. It's really very frustrating as expert when you've been told this is what you're going to do and you can't actually get started. And it's similarly frustrating for the party that wants to get going. I mean, I've seen appointing an expert drag on for over a year before. I've also seen cases where parties have actually had to revert to going to court to get an order that the expert determination process must proceed. And that's sort of a bit counterintuitive, given that expert determination should be quicker and easier and cheaper than going to court. But the reality is that if you can't get someone to engage, there's not much you can do. Many of you will have heard of the President's nomination scheme run by the ICAEW, that's the Institute of Chartered Accountants in England and Wales. You'll undoubtedly have seen agreements where it's a backstop position if the parties can't agree an expert. I'll talk about it a bit more later, but having received a nomination by the President to act as expert, there are still a lot of things that the expert's got to agree with the clients. They've got to agree the scope, they've got to agree fees, they've got to agree the timetable. So although the scheme does cut down some of the time arguing over the identity of the expert, there are still many issues that can be disputed before you can actually get going. So when you are appointing the expert, there are some key terms that need to be in the expert's terms of reference, and they're really quite crucial to avoid some of the issues that Gavin's going to talk about. Rob's mentioned some of these and getting them agreed up front, but that doesn't always happen, and certainly not in the level of detail that might be needed when you're actually appointed as expert. So I've kind of pulled out here some of the main areas that I think are important to focus on. The first one is the process. So the timetable needs to be set out, including deadlines and implications if it's not adhered to. So Rob mentioned that an experienced expert will set their own timetable. That usually starts from the receipt of a signed engagement letter by both parties. There's no point in having it start from if only one party signed your engagement letter, because again, you still can't really compel anyone to do anything. You need to consider simultaneous or sequential submissions, how many rounds, how to deal with questions, and whether each party has the right to reply to questions asked of the other party. A key theme you'll sort of hear throughout this webinar really is the non-compliant party and how we can try and make the process clear to deal with them. It's not always possible, but there are some things that you can do, and certainly setting out a clear timetable in the terms of reference to make sure both parties play by the rules is a good start. Now, Rob also mentioned situations where submissions can be introduced by parties outside the process. Again, if the expert's terms of reference need to state that the expert will not take those into account, and then they can do what they like. But if you've said you're not going to look at them, then nothing's going to come of it. The next thing to think about in terms of the expert's terms of reference is the items that are in dispute. Again, this should hopefully be addressed in your original drafting of the agreement, but it's not always as straightforward to make sure it ends up in the expert's terms of reference. Getting the definition of value right, I think, is a crucial one to have agreed in the agreement up front. But certainly if you're looking at completion accounts, you should really have terms of reference which have an appendix listing out exactly which items are going to be determined by the expert, so that everyone's clear on what's being covered. That means that if a party's trying to sneak new issues into the dispute once the expert determination process is started, then it can't happen if the terms state explicitly that that is not allowed. The next situation to think about is the reluctant payer, which I've already mentioned. Typically, there'll be a situation where, at the end, when the expert's done their determination, they obviously want to get paid. It's quite typical that we will all say that we won't issue the determination until we've been paid. And that is precisely because we know one of the parties isn't going to be happy. They're going to have to go out and pay some money over to the other party, irrespective of whether they agree with how much that is. So we will always have a clause in our terms of reference which say that if one party pays all fees, theirs and the other parties, then the amount due as a result of the determination will be adjusted to take this into account. So if both parties have signed up to this in our terms of reference, it should avoid a situation where the final determination can't be issued because of non-payment. You also need to give the expert the power to alter the process. So there may be situations where crucial information only comes to light in the last submission, and actually the expert doesn't have a complete picture of the situation from the little glimmer of information that might have come across, and might be concerned about drawing the wrong conclusion if they don't obtain more information. So sticking rigidly to the timetable in that situation would just be daft. And most people would also want the expert to have power to alter the timetable if, for example, a key individual in the process has personal circumstances that mean that they need more time. The expert also needs the opportunity to consult with third parties if needed. Typically, this would be either getting counsel's opinion on a matter of legal construction, or it could be an evaluation determination, getting input from a surveyor on market value of land and buildings. The expert should be required to seek approval from the parties before going ahead and incurring costs. And they'll usually ask for submissions on points of law from both parties before going to counsel, because if both parties agree, then we might be able to avoid that stage. Counsel's opinion is probably required more frequently than you might think. A typical scenario might be in relation to completion accounts dispute and completion accounts policies, where you might have something that says, the completion accounts shall be prepared on a basis which is consistent with last year's accounts and in accordance with UK GAAP. So that's UK generally accepted accounting procedures. But in this situation, what do you do if last year wasn't in accordance with UK GAAP? And you might think, well, surely if the accounts have been audited, they must have been prepared in accordance with UK GAAP. But actually, where items are not material to the accounts as a whole, they don't have to, the preparer doesn't have to prepare the accounts in accordance with UK GAAP in relation to that non-material item. So that means that it is quite possible for something last year to have been done in a way that wasn't compliant, and then you're stuck because the accountant's been told to do it on the basis consistent with last year and in accordance with UK GAAP. In those sort of situations, we're stuck between a rock and a hard place, and we'll usually like to get counsel to deal with that rather than try and muddle through it. Well, you can't. So we considered the need to give the expert power, but how much power should we give them? To be effective, expert determination needs to be final and binding, save in the event of fraud or manifest error. And manifest error was sort of mentioned in the case of Viva Oil and Petrotrade, where the judge said that it represented oversights and blunders so obvious and obviously capable of affecting the determination as to admit no difference of opinion. So there's a high bar to get over in proving manifest error, and generally the court is reluctant to intervene. So it's something where you want to give your accountant the opportunity to make determinations on some matters, but perhaps not all. For example, you might not want them to conclude on all matters of contractual interpretation, but in an accounting context, I'd probably argue that an expert is well placed to make determinations on what the contract says. Moving on to procedure. What is the best procedure to appoint your expert? Well, I would strongly recommend try and agree an expert, whatever you can do, if possible. It can be set out in the agreement, as Rob said, but that can often cause problems. Experts don't stay at the same firm forever. They don't necessarily retain the same fields of expertise. And Rob talked about potential sort of conflict or perceived conflict coming out from naming an individual. So the typical approach might be that one party proposes 3 experts and asks the other party to choose. The other party usually says, well, I can't possibly have any of those 3, and here's 3 of my own. And it can kind of go on and round like that. You can end up in a bit of a stalemate. But I very much say better the devil you know than the devil you don't. So, you know, hence, I think if you can agree, I would suggest you do, because it's very much a lottery if you can't agree and you have to go to the ICAEW President's Nomination Scheme. On that scheme, it now costs £10,000 for a nomination, mainly because the Institute doesn't want to be doing this. It doesn't really like getting involved in other people's disputes. The expert is nominated rather than being appointed, which used to be the case. In practice, that doesn't make a lot of difference. Even when the scheme was an appointment scheme, all the Institute did was remove the argument over the identity of the expert. All the points on agreeing terms that I've already discussed still applied. The 10 grand does not include the cost of the determination. I know Gavin had a client who was disappointed that they actually had to pay him, having already paid quite a substantial amount to the Institute. So yeah, that's worth being aware of. But in addition to the cost, the real issue with the scheme is that you can't really guarantee the experience of the nominee. The Institute says that it relies on its code of ethics, and it's certain that no self-respecting chartered accountant will get involved in doing something they're not wholly qualified to do. But I would tend to think that there might be some accountants out there who might consider this a nice little sideline, and they could just tick a box saying that's something they can do. So the short answer, agree an expert if you can. And finally, on output, you can have speaking or non-speaking determinations. Speaking determination will give you brief reasons. A non-speaking determination might say something like the shares are worth £14.91 each, or the value of spare stock is £750,000. Really, the advantages of the non-speaking is it's cheaper, it's quicker, and there's nothing to argue over. But that almost becomes the disadvantage of it, in that you don't really know how the experts come to their conclusion or what they've done. Clients generally prefer speaking because they feel more able to challenge it. But as I've mentioned previously, the court's quite reluctant to allow this. So it may just be giving a false sense of security. So I'm going to hand over to Gavin now to take you through what happens once you finally push the button.
Thanks, Kate. David, are we moving on to the next slide? So you've heard from Rob about the drafting process. You've heard from Kate about the appointing process. I'm going to talk from our experiences about some of the issues that can come up during the determination process. Obviously, this is based on our experience as acting as determiners. but the hints I'm giving are very much aimed at most of the audience who are lawyers in terms of the kinds of things for you to think about. And to be honest, a lot of these things are common sense. There's nothing that's special, but I think it's well worth going through some of the issues to try and avoid things escalating and becoming problems. So the first one, it seems very obvious, but agreed timescales. As part of the appointment, you will have agreed what the timetable is going to look like. It's important to communicate to your clients that they should try and meet those wherever possible. So sometimes things happen which mean that it's not possible to meet the agreed timetable. It might be that a client has a sickness issue or a personal issue, or it might be that it's taking a lot longer to obtain the information that's needed, particularly if it requires analysis. It's much better to explain that early on in the process, well in advance of a deadline, than leave it to the day and then say, sorry, we're not going to meet it. Apart from anything else, it allows the determiner to replan their diary and also everyone else to be able to work and set new deadlines. So always better to reach out to the determiner and seek an extension when it's required. Similarly, it seems very obvious, but when there's an information request, particularly coming from the determiner, then do provide a full response. It's very frustrating as a determiner when you've asked for specific information and you don't receive it. It's surprisingly common where that happens. Either it can slow the process down because you have to go back and check, but also it's obviously possible that a determiner may reach an inference if they've asked a question and information just hasn't been provided in relation to it. If something can't be provided, quite often where we're doing determinations, we might ask for accounting information that may genuinely not be in the power of the party to provide, but explain why. Say, the accounting system doesn't go back that far, or that's something that's not in our possession, etc. But don't just fail to provide things. Another obvious point, but it will normally be agreed by any experienced determiner that it's essential that the other party is always copied in to all correspondence. Actually, most determiners will suggest that even the submissions are made to them, often not copying the other side, and then when the determiner's got both, they will provide them to all parties. But don't start engaging in one-sided emails. It's surprisingly common where someone will try and send us a side email suggesting that that there's something that they want our opinion on, which I'll always reply copying the other party. So if you're doing that, there's actually a high chance that the other party will see the information anyway. Also, never pick up the phone and try and call the expert determiner. The same issue obviously applies. I think the most amusing instance I had was when one of the parties in a dispute actually called me up and asked me if I could suggest one of my colleagues to act as advisor to them in helping them draft their submissions. I'm always reluctant to turn down work, but that was one I had to very rapidly turn down and advise the other side that had happened. Seems obvious, but obviously the expert is, an expert in their field. Obviously, we're coming in as accountants, but they could be a surveyor or some other form of expertise. They're not a lawyer. They're not going to go beyond interpreting legal issues within their expertise. And it may well be likely that, if there are complex either legal issues or issues requiring other areas of expertise, it's quite possible that the expert might suggest bringing in outside expertise. My view would be where that's suggested, carefully consider before objecting to that, because most experts will only be suggesting that for a good reason, because they think it's important to the fairness and the ultimate outcome of the process. I've had people, objecting on fairly, in my view, spurious grounds, and do properly think about it. The last one is, hopefully how everyone on this call engages themselves at all times, but it's always better to be seen as a reasonable party. As a determiner, if one side does ask for, say, a 2-day extension, and the other side, readily agrees, then, it just makes the process much easier. Whereas sometimes you do have people who it feels are being difficult for the sake of it, and then that just makes the process harder for everyone. David, if we can go on. So obviously the hope is that this never happens, but what do you do if the expert goes off piste? What happens if they ignore the process in terms of timescales? What happens if they start doing things that should get the agreement to the parties? What happens if one party asks for something and they give it without consulting the other, etc.? Well, obviously, the key thing is in the first instance, if you think the other side is doing something unreasonable, then, clearly object, send, a clear, straightforward email setting out why you don't agree to the proposed course of action as soon as possible. So this could be things like, the other side trying to provide information out the process straight to the determiner. Maybe they're trying to change the process by, including an oral submission step, which hadn't previously been agreed. So do get your objections in writing. But, I guess what I would caution is it's probably worth considering, going back to my last point on the previous slide, whether there is an actual true issue that you really want to object to, or whether it's something quite reasonable, as I say, like a few days extension. So some of the things which, clearly might be issues is if you really do think that the experts, displaying a lack of independence, maybe, they don't seem to actually have the expertise they professed. And we've seen, examples of this on cases where questions asked by determiners are, sometimes surprising in the context of their apparent expertise, or, for example, you've actually found evidence of a potential error. So, as I say, set it out in writing if there is a real issue. Try and avoid threats. One of the worst things as a determiner, I don't mean physical threats, which I don't think I've yet received on a determination, although there's still time. But, it can be very common to get letters saying, if you don't do this, we will do Y, which ranges from, reporting you to a professional body to, taking legal action against you, to all sorts. Unless you feel it's absolutely necessary, avoid those, because the reality is that once the determination process is underway, there's actually very little you can do about it if you're unhappy with actions the determiner's taking. So some people, as well as threats, do think about withdrawing from the process. I would heavily caution against that. I had a case a number of years back where one of the parties was convinced that I was lacking independence because I'd made a decision on the process that they didn't like. And after making a lot of different threats, they did actually withdraw from the process. I actually got legal advice independently, which A, confirmed there was no issue over independence, but B, that the advice was that the determination should continue, but with that party, if they chose not to participate, just not being part of the process. So we carried on, and they didn't make submissions. They didn't respond to requests. And I issued the determination on that basis with them having not input. They made a lot of threats in the background. I think they tried to call pretty much everyone they could think of that they could complain about me to. But the reality is the determination went ahead, it stood. I never heard anything further about it other than the Institute of Chartered Accountants telling me that they were not investigating the complaint that had been made. And therefore, I assume, the determination was made without their input. If there is a concern of a major issue, it obviously may be possible to demonstrate fraud or manifest error after the event, after the determination's been issued. And I know there's a number of legal cases in this area. But going back to Kate's last point, you know, if it's a non-speaking determination and you've just got a number in front of you, it's probably going to be fairly hard to demonstrate those things. So, you know, having some form of reasoning often makes sense for those reasons. I think that is everything I've got to say about the during part. I think, David, are we back to you for questions now?
We are, thank you, Gavin. And we've had quite a number of questions actually being submitted during this, which is very good and possibly slightly surprising. So we'll try and get through as many as possible. See if we don't get through all of them, we will follow up with individuals that have submitted them. So the first question, have you had to deal with one side being consistently late or disregarding deadlines, and how have you dealt with that as the expert? That possibly one for you, Gavin, given what you were just saying there.
Sorry, my sound cut out on the second part of your question, David. Could you just repeat the second part?
I shall. Have you had to deal with one side being consistently late or disregarding deadlines, and how have you dealt with that as the expert?
Yeah, I think it's very difficult because where someone is, you know, constantly missing and it doesn't feel like there's any proper engagement with the agreed process, it's very difficult. I did actually have one where one was consistently late and asking for extensions on the day, and the other side did actually raise an objection. And you know, I did actually say that, you know, for future any further extensions, they should be asking for at least a week before that stage, so that, you know, there would be, you know, ability for everyone to plan. And actually that did seem to have the desired effect, and we did move forward. I'm not sure if Rob or Kate have got any examples on that too.
Possibly not.
No, nothing other than what you've said, really, Gavin. Other just sort of setting out that, yes, this is the process, and can they need to comply with it. And generally, people aren't too bad.
Okay, we'll move on to the next question. So, should pre-deal corporate advisors be doing more to get specialist input in drafting SPA clauses? And if so, who is best placed to provide that input? Potentially one for you, Rob, if it's pre-deal.
Okay, well, I mentioned Mandy Rice Davis again. Yes, I would, wouldn't I, in saying that? That yes, they should. And I think there's a combination really between the lawyers. As I said at the outset of my session, I'm not qualified to draft legal contracts, but I can look at them and say, well, what does that mean? How does that work from an accountancy point of view? And also with experience of what sort of things get disputed, again, you know, helps, because I said, well, actually, that's the sort of clause that causes a problem. You know, to give the example I gave earlier on, where it just says the value will be determined as such. What does it mean by value? You've got to define that. And sometimes people, they're so wrapped up in doing the deal. With the best will in the world, most of the corporate advisors, be they, you know, lead advisors from you know, a deal broker, be it the financial due diligence, be it less so perhaps the due diligence, but the corporate lawyer, may all be on a contingent fee, and they want to get the deal away. You know, I'm not saying they disregard these things, but I think somebody just stepping back and going, actually, do these clauses work? Because they're quite often, they're not central to the deal. You know, they're central to the deal, the headlines of how much and when and by what mechanism. And these things that go down the line that deal with completion accounts or earnouts and disputes are perhaps, you know, they're a bit lower down the priorities. So just having somebody who's not quite so wrapped up in the deal look at them, you know, I certainly think it's a good idea.
And there's one following on from that. So do you think costs are likely to be seen as prohibitive in getting pre-deal advice on SPA clauses? Or potentially, given what you've just said there, Rob, is it more about just trying to get it over the line and in time for a deadline?
Well, I suppose it's like anything else. It's got to be proportionate, hasn't it? You know, so if you've got somebody doing a 50 or 100,000 pound deal, they're probably not going to get the SPA reviewed. If you're doing a 50 or 100 million pound deal, you know, where the professional fees could easily be, you know, 2-3 million for doing that transaction, the thought of spending, you know, somewhere between 5 and 20,000, depending on complexity, to have the SPA reviewed as a bit of sort of insurance, if you call it that. I mean, it's trivial in the context of the overall fee. So again, small deals, yes, it might be seen as prohibitive. Larger deals, I think it'd be almost mad not to do it.
Yep. Okay, this next one looks like it's probably more for you, Gavin. Should submissions to the expert be in a particular format?
No, I mean, this is always an interesting question. But we see some that come kind of from the clients themselves, some that come from lawyers, some that come from, if it's an accountancy clearly matter, the accountants that they've engaged, and there can be quite different forms. I think, you know, for me, like with any document, the easiest it's laid out, and the easier you can kind of match it to the documents that are provided, it just makes the whole process a lot easier. Clearly, with responsive submissions, if it's responding to specific areas in the original submission from the other side, it's a lot easier to follow. So, you know, I would say, from my perspective, I have no particular view on the form it comes, as long as it's comprehensive and answers. What can be, on a slightly related point, slightly irritating is, you know, generally where one's making clear that responsive submissions should only deal with points that have been addressed in the other side's submissions, and someone suddenly tries to bring lots of new things into things, and that can be a challenge that has to be dealt with. But no, I don't know about the others, but for me, it's just like any report or legal document that's you know, well written and clear to follow.
Yeah, I would back that up. And if there's various attachments and so on coming in with submissions, reference them and make them just almost idiot-proof, so that it's clear what documents relate to what part of it, and you're not having to spend lots of time wading through attachments and exhibits to try and figure out how they relate to some of the issues.
Well, and one other thing actually, that, you know, if on accounting things, if documents can be provided in Excel, we'd much rather have them in Excel than have PDFs printed from Excel. You know, it's something I'll often specifically say at instruction point. But, you know, if you want to keep an accountant happy, send them an Excel spreadsheet.
The only thing I'd add to that, David, is just, it's when at the very first submission, sometimes I think if people have been trying very hard to resolve things themselves before going to expert determination, sometimes they can kind of launch into the submissions halfway through without actually kind of giving you enough of background as to what the issue relates to and how it's come about. So you kind of almost end up the first round or two of submissions, it's almost when you get to the questions, you can kind of go, so what are you arguing about? So just giving enough of background.
People also ask, you know, should they do it if you know, we act, all four of us act as advisors sometimes on submissions as well. And people say, you know, should you do it in your name? So should the accountant, if there's an accountant, somebody helping, do it on their branded? I don't think it makes any difference. You've got a proper expert determiner. They shouldn't care if there's a you know, a recognised expert's name on the submission. What they care about is the quality of the submission and the clarity that it is, as David said, well ordered, well structured, is easy to follow. Now, that might be more so if it's a recognised expert producing it, but they don't need to produce it on their own letterhead. They can produce it on your letterhead. They can produce it on plain letterhead. The main thing is it's well structured, well organised.
And I think we can always tell if an accountant's been involved in drafting it, even if it's not on their headed paper.
Okay, we'll move on. There's a couple of questions in relation to the President's nomination scheme. First of all, do they seek out the best placed expert for the case, or do they just pick the next name on a list?
I'm happy to answer that one. It's not entirely transparent, but I'm pretty sure it's not just the next name on the list. I know that they will sometimes make selections based on specific requests. So I know I've been appointed through the scheme because somebody wanted a geographically local expert determiner. I mean, given that as expert determiner, I've certainly never gone and actually met somebody, and everything's been done very much at arm's length. It didn't really matter, but I wasn't going to say no. They are also supposed to have a bit of a look at kind of general cost levels and try and think about that. So, for example, not appointing perhaps one of the largest accountancy firms to determine a dispute over £5,000. But you know, it's not fail safe. So it's not the next name on the list, but it's not necessarily a very closely thought through matching process.
I actually got an inquiry from being in Scotland, ICAST, not that long ago, and it was from the expert, it's from the President's appointment list, and they sent through the background to the case and asked for me to consider it and say, look, is this something that I felt comfortable with, and did I want to put my name forward for it, which was quite good. I thought it actually gave you time to consider it and think, actually, is this within my area of expertise or not? Okay, there's another one in relation to that same scheme. Given the President's section of the ICAEW now only agrees to make nominations of experts where it is a joint application, how would you suggest this be dealt with in the drafting of the expert determination clause in case one party refuses to cooperate? Possibly for Rob or Kate.
On that one, I think I'd probably say, well, if the expert determination clause states that the parties agree to be bound by the nomination, then I think you're bound by it unless you know someone says otherwise. I mean, the institute isn't going to do anything to force you to use that individual, but I think if you say you will go to the institute, ask them to make a nomination, and then you both agree that that individual will be nominated, then
typically I don't see a big issue with that. You know, quite often it'll say people have got 14 days to agree an expert, and I think I can't remember, it was Governor Kate said, names get put forward, and sadly there's quite often a knee-jerk reaction from the other party. Well, if they put them forward, I don't want them because they must already know them. I think that's very, very rarely the case, that is a real issue, even if it's a perceived issue. Whereas if the expert determination clause says, an expert will be appointed by agreement within 14 days, failing which, reference will be made to the ICAW or any other body that can nominate experts.
Okay, thank you.
Sorry, David, I did see another question. I'm not to do your job for you, but I did see another one that was someone saying, why not the ACCA? So as opposed to the ICAEW, and unless something's changed, they don't offer the same scheme. So that's why not.
Okay, thank you. The question on cost allocation by the expert. Is this always accepted by the parties? One for you, Kate, possibly.
So this is presumably when we will issue our determination and say, okay, well, I think costs should be shared in this way. Very, very often it might be equally between the parties, but if one party's sort of caused a lot of extra work, or perhaps if one party's received more of the value that's being allocated, we might do it differently. Generally, what would tend to happen is that we might make that allocation, but then, as I mentioned before, we have the clause that allows one party to pay both sets of fees. So we kind of make that allocation and kind of send it off into the ether, because the party should have agreed as part of our terms of reference that they will alter the amount in the final award based on the costs that are required, the costs that need to be paid. And if one party pays the other's cost, then the award will be adjusted as a result. So that should address that issue.
Okay, thank you. Now, there are a number of other questions, but it is now 1:30, so conscious of time, so we'll have to wrap up at this point. We will respond to the individuals that submitted questions that we didn't get time to answer, so that you will get an answer to them. The recording of this will be distributed next week, and a big thank you to Kate, Gavin and Rob for their input today. Some very useful insights from all of them. Big thank you to you, the attendees, for making the time to join us today. Hopefully you found it useful. And that's pretty much it from us. So thank you and have a good afternoon.